whether the minimum age of tribunal ought to go for 50 or less is within the exclusive domain of the executive and parliament and cannot be dependent on the views of this court, being a pure policy issue. Now, the first challenge, this policy issue I will deal with, it was raised 4 times, and all the 4 times Supreme Court said no. Once tribunals are discharging judicial functions, court has a say. I'll come to those passages later. Now, (91.2). So it was not experience or maturity, which the Attorney General argued. It was a person can't be additional secretary till become 50. Therefore, on the principle of equivalence, we are putting 50. Please come to para 91.2. Considerations of equivalence. Para 91.2, next paragraph. Page 471. Considerations of equivalence with additional secretaries.
One way.
Sorry, sir. May I read, Lord? The challenge to the first proviso to section 92, sorry, now 91.3, 91.2, considerations of equivalence with additional secretaries weighed with the union in enacting the age qualification. 91.3, whether the minimum age of tribunal ought to go for 50 or less is within the exclusive domain of the executive and parliament and cannot be dependent on the views of this court, being a pure policy issue. Now, the first challenge, this policy issue I will deal with, it was raised 4 times, and all the 4 times Supreme Court said no. Once tribunals are discharging judicial functions, court has a say. I'll come to those passages later. Now, please see what Honorable Justice Bhatt says in these passages. The challenge to the first proviso to section 184, which prescribes the age qualification, has to be seen from several angles. First, the underlying parent statute which created the tribunals, ITAT, CSTAT, TDSAT, CAT, did not prescribe as an eligibility criteria for selection of candidates as members any minimum age. The prescription of 50 years as minimum eligibility criteria, in the opinion of this court, is without any rationale. ITAT has existed for the last 79 years. No less than 33 of its members were appointed as judges of various high courts. One of them, Justice Ranganathan, was appointed to this court. CSTAT 2 is comprised of advocates who have staffed the tribunal efficiently. The absence of explanation for preference given to older persons, in fact, leads to an absurd result, as pointed out in MBA 3 and has been reiterated by L. Nageshwar Rao in his opinion. The Constitution of India makes an advocate who has practiced for more than 10 years eligible for consideration for appointment as a judge of the High Court and even this court. An advocate with 7 years practice with the bar can be considered for appointment to the position of a district judge. Prescribing 50 years as a minimum age limit for consideration of advocates has the devastating effect of entirely excluding successful young advocates, especially those who might be trained and competent in a particular subject, such as indirect taxation, anti-dumping, income tax, international taxation, telecom regulation. The exclusion of such eligible candidates in preference to those who are more than 50 is inexplicable and entirely arbitrary. The High Court, Supreme Court has said it is arbitrary. As this court in previous has pointed out, exclusion of young and energetic legal practitioners could result in not so efficient and competent practitioners left in the field for consideration, which would have the telling effects on the quality of decisions they are likely to render. Now, para 93. Prescribing 50 years minimum age as a condition for appointment to these tribunals is arbitrary because no reason is forthcoming about what impelled Parliament to divert from the long established criteria giving weightage to actual practice, reputation, integrity, and subject expertise. This is the biggest casualty today, subject expertise. Without a minimum age criteria in the pleadings in this case or in any other case, such being the case, it is astonishing that in a span of 1 year, new thinking seems to have prevailed to frame rules excluding advocates who can otherwise, based on their expertise, be considered for appointment to even the high courts. This court would observe that consideration of younger advocates in the age of 40 to 45 would have long-term benefits, since the domain knowledge and expertise in such areas, telecom, etc., would be useful in adjudication in tribunals and lead to a body of jurisprudence. Depending on how such counsel advocates fare as members of the tribunal, having regard to the special knowledge of these laws at a later appropriate stage, they may even be considered for appointment to the high courts. Then, my lord, then his lordship says next para it leads to absurd results. Then after various judgments are discussed, to save time, my lord, I'll straight away go to para 103. Para 476. In the present case, may I read from page 476? Just to conclude, I want. In the present case, therefore, the qualification of a minimum age of 50 years as essential for the appointment is discriminated because it is neither shown to have a rational nexus with the object sought to be achieved, that is, appointing the most meritorious candidate, nor is it shown to be based on any empirical data, study or data, that such older candidates fare better, or that younger candidates with more relevant expertise would not be as good as members of tribunal. It is plain and simple discrimination based on age. The criteria of 50 is virtually picked out from a hat and wholly arbitrary. So once the Supreme Court has said, now, my lord, if Parliament can show on the basis of empirical data, studies that no, this is a particular reason, I can understand. But the ordinance has been discussed, been struck down, and the same thing include. And my humble submission is that has to be followed. 50 has to be struck down. You can't say because additional secretary becomes at 50, therefore I should. But in fact, I remember, if your lordship sees just Hidayatullah's autobiography, my own Boswell, he points out a person who joins the ICS. Now, at the fourth year in ICS, you take choice. Either you go to the judicial branch or this. Now, ICS judge would become a High Court judge only at the age of, in those days, at 52, 53. Because he would become first in this as a civil judge, then district judge. He would take almost 20, 25 years to reach the High Court. Whereas a member of the bar could advance much earlier. So he points out that those people, some who could not make the ICS, ultimately became judges before the person who joined ICS and came. So that can't be a criteria because an ICS person will take 50 years to become a judge. Therefore, no member of the bar also can take 50. That can't be the logic. There's a good chapter in my own Boswell on this.
His father was an ICS officer.
His father-in-law, P.N. Shah.
No, his father was also an ICS officer.
I see, I didn't know. Because from Nagpur, I was his father-in-law also was P.N. Shah. I think.
Father-in-law, I don't know.
Yes, father ICS.
Father was because the Tajuddin Baba story that to which he narrates in his autobiography. His father was the additional district magistrate at Chinwada.
Chinwada.
When Tajuddin Baba visited his place and told his father that one day this boy would be in the Rampur. That chapter you have missed.
In fact, the story goes that when the Oliver Wendell Holmes' father was a doctor, in fact, he reduced the death.
Father?
Oliver Wendell Holmes' father. In fact, he had insisted of people washing their hands, and that reduced the black death where babies would die because of infection. So when the story goes that when Oliver Wendell was an infant, somebody held his finger. So he writes that I'm holding the finger of the future judge of the Supreme Court. The story is below. Now, my lord, so my humble submission is 50 is to be struck down.
Tajuddin Baba had given him a piece of the bidi smoken by him.
Oh.
And he said that he kept it with him till his end.
Oh. Yes. Now, my lord, now this question. So this stand taken now in the union, in respect, is untenable because the stand taken in the earlier case was additional secretary equivalence, not policy, maturity, give it a chance. No, that is not the reason. In fact, all along, all tribunals, in fact, CSTAT, so many judicial members.
The very argument that the majority comes only at the age of 50, something.
Yes. And again, as I argued also last time, I mentioned that we ultimately is headed by a Supreme Court judge with two secretaries, two judges and two secretaries headed. Don't confuse eligibility from suitability. When you make the eligibility as 40, 45, the pool is increased, and then you select. Number one. So then sorry. Yes, yes. I'm grateful. Lord, I'm grateful to my friend. Please see para 107. Lord, your lordships have given number of judgments saying you can't compare judges with civil services. They're different and so on. Though quasi-judicial members of tribunals are central government employees, they are central government, they get salaries, not from the, not a high court judges, but from the thing. But you can't equate the two. Now, what has happened is this, my lord, my humble submission, which I've been arguing, this entire system of tribunalization is taking away large parts of the jurisdiction of the courts and giving it to tribunals. In fact, if we had lost the National Tax Tribunal, when we started, NCLT and NTT were heard together, but NTT was detagged because NTT was under 323B article. That was heard separately and that was struck down, saying that decision of substantial questions of law is a judicial function and our policy is separation of powers. A tribunal can't be entrusted to be the final arbiter of what is substantial question of law. That was the point. There, one point we made was company law is fully gone. If taxation also goes, high courts will have nothing but CRP and 482 and 226 and 115 CPC because there's no tax bench, there's no company bench. Now, please see 107. Page 478. Thanks. There are other points of distinction too between civil servants and members of tribunals. Members of tribunals are not drawn from any civil service. They are not holders of civil posts. Civil servants, especially members of the All India services recruited by the union, some of whom are deployed to different states, are governed by rules and other service conditions embodied in circulars and orders. These govern their entire universe of employment, starting with eligibility conditions, rules of recruitment and selection, pay, allowance, seniority, promotion, discipline, and other matters. On the other hand, such rules or similar rules do not apply to members of tribunals not drawn from public service. It is only conditions of equivalence, such as pay scale, which they are assured under the rules, which also determine the status. The manner of selection, conditions of eligibility, rules for their removal, upon proven misbehavior and so on, are entirely different from public servants. In fact, the latter category, i.e. members of tribunals, are not drawn from public sources, are not even holders of civil posts or members of any encadred civil service. This has been clarified in at least 2 judgments of this court. His Lordship gives that they are not governed by Article 311, nor are their conditions of service laid out in rules framed under the proviso to Article 309. Such being the position, the argument of parity in the opinion of the court is also devoid of merit. Nor is the argument under uniform age of 50, so and so, so and so. So, my lord, this entire thing has been discussed by the Supreme Court, and the other concurring majority judgment of Justice Nageshwar Rao is also discusses this point. The 50 is also accepted by him. Yes. Sorry, ITAP? No, 10. Yes, 109 also here. Yes, yes, important. Para 109. Purely as empirical data, page 480, ITAT has a sanctioned strength of 126 members, which includes accountant members, technical members, who are drawn from the Indian Revenue Service, holding the rank of Commissioner of Appeals for 3 years, and advocates. 66 members presently are in office, appointed since the year 1999. Of these, 10 members were below the age of 40 at the time of their appointment, 20 members were between the age of 40 and 45, and 15 members were between the ages of 46 to 50 at the time of their respective appointments. Cumulatively, 44 out of 66 members were appointed below the age of 50. Only 17 members were above 50 or above at the time of their appointment. data is not provided in respect of 5 members. This data, as indeed similar data from other tribunals, shows that past appointment to this position was amongst younger and competent persons. The union has not shown why this past history requires departure and why that long-standing basis for appointing younger professionals now needs to be departed from in public interest. Significantly, Commissioner Appeals of Income Tax in the respective service rules typically are appointed after 18 years or so of service. If one adds 3 years, an incumbent commissioner would be well below 50 years. He or she would be completely familiar with adjudicatory and tax laws. Exclusion of such otherwise qualified and suited personnel too is irrational. So even from the revenue side, a person would be a commissioner. He'll be below 50, but he'll be a commissioner with experience. He can also be a good technical member. Having regard to all these reasons, the union's argument that 50 years is necessary as it brings about parity between members of the civil service who are eligible to be considered in their stream for tribunals, or that there's overall uniformity, is without merit and also rejected. Yes. Now, my lord, on this, the second submission, and now para 112.
That you have read.
Right, yes. Now, my lord, now one point I raised in my written submissions, one argument of the Attorney General was it's a matter of policy, deference to the state, etc. How the Supreme Court has said, in the context of tribunals, what is the role of the court? And what is the say the court must have? That Lordship will kindly see. Please come to para 96 of Madras Bar. First, Madras Bar. Yes. One. Yes, please come to page 89. Remind me again.
Madras Bar.
Yes, yes.
One.
First Madras.
Page 90.
Yes. Page 89. Yes. Please come to what's the role of the Supreme Court? Please come to para 96 of the first Madras Bar. And if your Lordship so pleases, in my written submissions, in the written submission which I given today, please take my written submissions para 4.4. It's the same thing, I've reproduced it. Your Lordship wants to see the main judgment, or Your Lordship will take
What's all right?
in the written
It's a
submission.
provision for you then.
Yes, it's easier, my lord. I just culled out the actual portion. Please come to page 9. But there also the argument was, when we did the first matter in 2010, the argument was that, look, these are all policy matters. What to go out of the High Court is for us to decide, because under the entry 77 of the Constitution, administration of justice is a subject matter of Parliament. So Parliament can say what matter will be with the courts, what matter will be with the tribunals, who should be they said the Constitution says what's the qualification for a High Court judge. But once it comes to tribunal, it is for Parliament to have the say. Now that is held to be not correct by the Honorable Supreme Court. Please come to para 96 at page
9.
Page 9. The question is whether a line can be drawn and who can decide the validity or correctness of such action. The obvious answer is that while the legislature can make a law providing for constitution of tribunals and prescribing the eligibility criteria and qualifications for being appointed as members, the superior courts in the country can, in the exercise of powers of judicial review, examine whether the qualifications and eligible criteria provided for selection of members are proper and adequate to enable them to discharge judicial functions and inspire confidence. So qualification eligible criteria are amenable to judicial review. Now kindly come to the next part at page, para 4.5. This is 2014 where the entity was struck down. Again, Constitution bench. Page para 107. Even though the legislature can reorganize the jurisdiction of judicial tribunals and can, page para 4.5 of my written submissions, page 107, page 10, para 107. Lordship has got it, Manu?
Yes, MBA 2014.
Yeah. Even though the legislature can reorganize the jurisdiction of judicial tribunals and can prescribe the qualifications / eligibility of members thereof, the same would be subject to judicial review, wherein it would be open to a court to hold that the tribunalization would adversely affect the adjudicatory standards, whereupon it would be open to a court to interfere therewith. Such an exercise would naturally be a part of the checks and balances measures conferred by the Constitution on the judiciary to maintain the rule of separation of powers, to prevent any encroachment by the legislature or the executive. So again, Your Lordship has said that we will have the power to decide whether the qualifications eligibility are
in consonance
proper,
with
because they're going to exercise judicial
maintenance of the
Yes.
judicial standards.
See what, for example, NCLT, if you are going to take over the company law, then court can say what should be the qualification. You're going to take over taxation, DRT. What are all civil jurisdictions have been taken over. Nobody says, tomorrow you say that nobody can be a colonel till he's 40, Your Lordship can't interfere. Or if you say a directorate of fisheries must be 55 years, then that's not for Your Lordships to interfere. But here when it comes to quasi-judicial prayer, you want to take over judicial functions and then subject it to executive control. That is not permissible not in our submission. Now, please see para 4.6. Again, this has been raised again and again and again. It's a matter of policy. Court should defer to legislative wisdom, will of the people. All those arguments have been raised again and again. Now, please see at 4.6. This is MBA 4, para 81. Just now I read para 91 onwards on 50 years. This was on the same submission. The argument of Union of India on deference to policy was once again raised in MBA 4. Bhatt J held as follows. In all these decisions, this court scrutiny was based, before 80 number of judgments are cited. I think if your Lordship wants to see that. Now, in fact, my Lord Justice Bhatt goes to MBA 1, MBA 2, R. Gandhi, all those things. That if your Lordship wants to see that, I'll take your Lordship to that.
It was considered, Roger Matthew also.
Yes, Roger Matthew also. This para 81 will be at page 470. I think we'll just go. Lordship, just permit me.
81 is at page 466.
466. And Lordship will kindly see. Yes.
As they refer to
page 459 is
2010, then 2014 Madras Bar Association.
Yes.
2015, then Roger Matthew.
All are discussed. And then finally it comes to Chandra Kumar, Ismail Faruqi, everything, Sampath Kumar. And then at 81, at page 466, in all these decisions, this court scrutiny was based upon its role as the guardian of the Constitution and more specifically independence of the judiciary. If one were asked to pinpoint any specific provision of the Constitution that this court relied upon when holding the enacted provisions to be falling afoul of, there would be none. Very, very important. If you can say that what is the provision which the court has the power, there is none. It is too late now to contend that independence of the judiciary and separation of power are vague concepts based on which parliamentary reenactment cannot be invalidated. The role of this court in considering whether or not provisions of law or executive policies are in consonance with the Constitution is well recognized and cannot be overemphasized. The Attorney General's assertion that an executive, etc. Yes. But what's the most important thing, Lord, is this. Paragraph 80. And now Lordship will come to para 89. at page 469. This court, as the ultimate guardian of the Constitution and the rule of law which it is sworn to uphold, has been asserting its role in regard to matters of appointment and other conditions of service of judges of district and other courts. Since tribunals function within the larger ecosystem of administration of justice and essentially discharge judicial function, this court is equally concerned with the qualifications, eligibility for appointment, procedure for selection, conditions of service, etc. of their members. The court's concern, therefore, is unlike any other subject matter of judicial review. It cannot be gainsaid that if tenures of tribunals or members are short, say 2 years, or salaries are pegged at unrealistically low levels, or if presiding members are given no administrative control or powers, the objective of efficient, fair, impartial justice will be defeated. It cannot be argued that each of these are policy matters beyond the court's domains. Then, my lord, para 90, it goes into policy issues, and then 91 will start. Now, my lord, so my humble submission is, and ironically, one thing, here also today, the Act says 50 years, but the rules say advocate with 10 years experience for IT and so on. The rule says 10 years only. But the Act says 50. Yes. So, my lord, the first submission to meet what the learned attorney said, 50, has been rejected decisively by this court. And not only it's a matter of policy, the Supreme Court has gone into empirical data to show how a vast majority of members in the past were below 50. And I, as a person who has practiced in the ITT for many years, I can honestly say, my lord, it was one of the most wonderful experiences at that point of time. It was a really outstanding tribunal that, in fact, Sachar committee recommends ITT is a well-functioning model. Please adopt it for CLB and for CSTAT. Sorry, for CSTAT. That's how CSTAT came in 1982, technical member and judicial member. So, my lord, I have finished on 50. I have finished on this policy
decision.
Yes. And also on this legislative override. Only one point remains is selection, search cum selection committee, and then I have concluded.
And that
Tenure 5 years.
and tenure of 5 years and panel.
5 years. Yes. Number 5 years also has been dealt with, Your Lordship. I'll just finish search cum selection committee, then come to this. Now, Lordship will kindly come to take your written submission, sir. Lord, yesterday, sorry.
My lords, the learned attorney will not be able to make it at 2. So I have been instructed to hand over learned attorney's note for your lordship's kind consideration.
Finally, we'll be getting the opportunity of your assistance.
Lord, yesterday on the search cum selection committee, I already read the passages earlier where they said it is completely destructive of independence, both by Honorable Justice Nageshwar Rao and Justice by Bhatt. I don't want to repeat that. Here the mention was that why are they doing 2:1? Well, our first submission is once the search cum selection committee is headed by a Supreme Court judge, another judge, and 2 members, 2 senior secretaries, the executive has a full say in the appointment. Lordship will see the composition of committees. There is 1 Supreme Court judge, president of tribunal, and 2 secretaries. So Supreme Court judge can technically be in the minority also.
Three secretaries.
No,
No.
Third
Yes.
secretary. He doesn't have a vote.
Yes.
The member secretary doesn't have a vote.
Because yesterday I chaired one meeting.
But maybe the member secretary will not have a vote, maybe.
It was signed by 5.
I believe he gives his inputs.
Does he have a vote?
No, my lords, member secretary does not have a vote and the presiding judge has the
Casting vote.
casting vote, my lords.
Sitting judge, president, two secretaries.
Yes. No, just show any one composition. Just like any one composition. Well, I'll just, your Lordship, just your Lordship. 299, just who the search cum selection committee for State Administrative Tribunal, Chief Justice of the High Court, Chief Secretary concerned, Chairman of Public
299 of your
of the writ petition. Sure.
written submission.
I'll show Central Tribunal, not a state government. No, there's a chart. Where is the chart?
Except for the essay.
Yeah. Lordship will come to page 298 of the writ petition. Section 3 talks of search cum selection committee. Lordship will just not wait. I'll just, your Lordship, who the what's the composition? Search cum selection committee except for State Administrative Tribunal. That is for all other tribunals. Lordship has got what?
Yes.
Chairperson, who shall be Chief Justice of India or a judge of the Supreme Court nominated by.
Provision are you reading?
Page 298, section 3 of the Impugned Act.
Yes. Not
3.
Yes.
Search cum selection committee except for SAT shall consist of chairperson who shall be Chief Justice of India or a judge of Supreme Court nominated by him. 2 members who are secretaries to the Government of India nominated by the government. 1 member who in the case of appointment of chairperson of tribunal shall be outgoing chairperson of the tribunal. In the case of appointment of tribunal shall be sitting chairperson of the tribunal. In the case of chairperson of the tribunal seeking reappointment shall be a retired judge of the Supreme Court or a retired Chief Justice nominated by the Chiefs of India. Provided in the following cases, such member shall always be, etc., etc. Now, my lord, come to D. Secretary to the government, page 299D. Secretary to the Government of India and the Ministry or Department under which the tribunal is constituted or established, member secretary. In fact, another one matter which is pending in the court is from Chandrakumar, they say let all tribunals come under the nodal ministry for effective, as a ministry of law, it should be to start with, and not individual members. That is still pending, and that has to be decided sometime later. But today, your Lordship's question is, this member secretary, who your Lordship said is the 5th person, has no vote. Please see page 299, subclause 5. Subclause 4. Chairperson of the search cum selection committee shall have casting vote, and 5 member secretary shall not have any vote. Then 7 is the impugned provision. Notwithstanding anything contain any judgment, order, etc., the search cum selection committee shall recommend a panel of 2 names for appointment to the post of chairperson or member, as the case may be, and central government shall take a decision on the recommendation of that committee. Preferably in 3 months, yeah. Now, my lord, two points come here. One, the argument was that people apply for many tribunals and then don't join. And therefore, we don't want a situation where there are 5 posts and we recommend 5 people and 2 don't join. Again, the whole thing becomes a... 2 answers are to that plot. One, this question of 2 persons is our submission has been struck down by this court. Our submission is, since it's a quasi-judicial tribunal, since it's a body discharging judicial functions, and there is adequate participation by the executive, they cannot be a super selection or selection of a selection. Once the committee has selected X number of candidates, then the appointment to be made by the appointments committee, ACC, has to be strictly in terms of the merit given by the search cum selection committee.
No, what is your contention?
My submission is, first of all, this 2 is to be struck down. If your lordship says no, 2 is okay, because you may have wait list, you may have situation where there are 6 posts, and if you only give 6 names,
Even if there is a wait list, but you are saying that it's struck down.
no, I'm first submitting that
This,
recommendation of 2 should not be there.
no, but whether it is already set aside or
They already set aside. Already set aside. Yes, it's completely set aside. That's why they put notwithstanding any judgment. At least in this position, they put notwithstanding any judgment. Now, second submission I'm making is the question of, was it only 2? Was there also? Yeah. The other submission I'm making is, even if there is a waiting list, suppose the requirement is
then
that
it should be strictly in accordance with the merit,
in a merit.
merit list.
Merit list. Now, the fact remains, when yesterday I mentioned about the Bangalore Bar judgment, there is a specific judgment of this court in that contempt petition, where what happened was, out of the candidates, 6 came from the waiting list and not appointed from the merit list. In fact, in the ITAT selection, the person who came second is not selected, but the person who was in the waiting list was a member. And that has been recorded by the Honorable Supreme Court. In today's compilation, which your lordship has got in the written submissions, please come to page 59 in today's compilation. This page 59. The contempt proceeding related appointments of ITAT. Now please come to para 4. Out of 28 recommendations in the main list, well, there were 41 vacancies. Lordship will kindly see at para 2, I'll read para 2. An advertisement was issued for 37 vacant posts.
We are reading page.
Para 2 at page 59. Advertisement issued for 37 vacant posts of the ITAT, of which 21 for judicial members and 16 for account. Page 59, para 2, my lord.
Please.
May I read, my lord? Page 59 of the written submission.
Yes, please.
Yes. On advertisement issued for 37 vacant posts on 6 July 2018. 21 for judicial members, 16 for accountant members. The selection process was set in motion. The search cum selection committee was headed by Justice So-and-so, Honorable Judge, Supreme Court of India. Now kindly see the dates. On 21st September 2019, SCSE recommended names of 41 persons for appointment as members of ATAT. The reply has been filed by so-and-so. The SCSE had recommended 28 persons, 16 as judicial members, 12 as accountant members in the main list, and an additional 13 persons in the wait list. So 28 in the main merit list and 13 in the vacant list, in the wait list. The recommendations received on 3rd October 19, submitted for consideration to the appointments committee in 16th October. The appointment came in September 2021. And I'll show you a chart later that all appointments take much more than the 3 months prescribed. Here also it came after 2 years. But now the problem is this, out of 28 recommendations in the main list and 13 in the wait list, the ACC selected 16 from the main list and 6 from the wait list. So, my lord, there is data to show that they have skipped the merit list and gone to the wait list.
I'm one of those people affected. They went below me and selected. I'm number
Yes,
one at the wait list. They went-
Now, why did they do this? Just to save time, my lord, your lordship will see this order. What happened was, after the search cum selection committee report, the affidavit filed by the union, because here, my lord, I was appointed as amicus also here. The affidavit filed was, IB report came later. IB report.
IB report should precede the.
No, that's what this court directs. This court directs, the direction has come in this judgment of this bench, that IB report should be placed. Then there is a further interesting thing. Before the cabinet committee, there is something called feedback, a column called feedback. So they said on the basis of some negative feedback, we did not appoint. So the Supreme Court said IB report plus any adverse comments should be placed before the
Search committee, search compilation committee.
even if after the SCAC is gone to it and the search come in the cabinet committee, some new material come, that again should come back to the search cum selection committee. Ultimately, everything should come. And now kindly see the passage. Yeah, please come to paragraph. Yes. Now, my lord, at para 8 is the submission of Mr. Basant. Then para 9 is my submissions. And my lord, what is important is learned attorney fairly sub para 11. Para 11. Para 4. Yes. I've read. I've shown this out of 28 years. I've already shown. Please come to para 11. The Attorney General, however, page 63, para. The Attorney General has fairly submitted that where subsequent inputs have been drawn to the attention of the competent authority after submission of recommendation by SCAC, it is fair and proper that these comments, together with the original IB report, are remitted back to SCAC to enable it to apply its mind to the materials placed before it. Along the same line, it has been stated by Attorney General that in the future, it would be ensured all inputs which are available to the government, whether from the IB or any other source, including the Central Board of Direct Taxes, should be placed before SCAC in advance before it makes recommendations, so that these inputs were duly borne in mind in an appropriate manner before recommendations were finalized. And in the present case, objections of the competent authority to some of the recommendations by SCAC should be placed for consideration so and so. Number one, why Central Board of Direct Taxes? In some cases, the feedback was some penalty proceedings have been taken against the candidate. So I pointed out under section 270 of the Income Tax Act, if I report income of say 10 lakhs and they assess it as 20 lakhs, automatically they take penalty proceeding. That doesn't mean there's actually some contumacious conduct. So the feedback was some income tax penalty proceedings are pending, therefore that man is disqualified. Now, what we said was, with all fairness to the Attorney General, he said, yes, we will give IB report, no feedback at a later stage. Whatever is there should be before the SCAC, and that should be the final decision. That's what this particular says. Number one, so this judgment is discussed in detail. Please come to para 66. Page 66. Just about 5 lines from the 6 lines from the top, a comprehensive exercise. Lordship has got. Page 66, about 7 lines from the top. Lordship has got it. A comprehensive exercise. A comprehensive exercise. Yes, my lord has got it. My lord, the Chief Justice has got it. A comprehensive exercise. Yes. A comprehensive exercise conducted by the committee inter alia, calling for inputs from the IB, verifying the record of such candidate, and conducting personal interaction. What do you think? From the verifying the record of each candidate. Hence, all such inputs, such are available to the government, must be placed before the SCAC in advance. In exceptional situation where certain material comes to light after submission of recommendations, that must also be drawn to the attention of the SCAC so as to enable it to consider whether any modification of its recommendation is necessary. In view of the above discussion, we are of the considered view that the feedback which has been tabulated in the file note before the competent authority must be placed before the SCAC to enable it to consider whether any modification of recommendations is warranted. If the feedback is based on tangible underlying material, such material should be placed before the SCAC. They should carry out the exercise. Now, their matter was sent back. But my humble submission is that as far as SCAC is concerned, 2:1 has to be struck down. If your lordship is pleased to uphold it, then the appointment must be only in the merit ranking given by the committee and no other. And till the merit is exhausted, wait list.
But if bench consisting of 3 judges has set aside such a requirement, can
No, you cannot. No, no, my friend, so I don't want to refer to larger bench and so on. I'm saying that that's not necessary at all because it's a salutary process.
It's a 3 judges bench and we are sitting in a
Come on,
combination
yes.
of 2. So
Yes, yes.
can we take a contrary view?
Cannot able to. And what I'm submitting is, when was it in the past? Tomorrow you will say for district judges, there'll be there'll be 2 will be selected per vacancy and the governor will appoint 1. That can't be done. Even in the past also, where's the question of ITAT having double the number and it is? In fact, I remember my colleagues who have appeared before just Rumapal and others and got selected. There's no question of 2:1. In fact, 19% selected by Honorable Justice Rumapal was not appointed for several months. There's some rule, if the selection doesn't take place for 18 months, then it has to be gone afresh. They didn't want to appoint that. Then we moved again. MBA moved the High Court. It came to Supreme Court and they said, no, you can't postpone like this. All appointments have to come through. So all the 19 names had to be appointed because of Supreme Court direction. They just kept pending. Number one, finally, if there's 4 years, Lord, in Sampath Kumar, Justice Bhagwati elaborately discusses that you are going to select people. Now, today, my Lord, if a Lordship sees the technical member qualification, it is very wide. Virtually any civil servant can apply for the job. In company law also, he need not know company law. He can have knowledge in economics, accountancy, and not less than so many years experience as a so-and-so post. So what Justice Bhagwati says is, look, your members of the CAT and SAT are going to be from various spheres. Service law is a special branch of jurisprudence. They will take some time to learn on the job. And 5 years is really a short period. Therefore, automatic extension should be provided. That is why they said 5. Now, what happened in Roger Matthew was they made it 3. That was struck down, saying 5 should be there. Now, my Lord, I don't know if it's an ego issue, but now they made it 4. Why 4? I don't understand. Supreme Court said 5. You said 3 was struck down. Now you make a Wikimedia of 4. So and there is the argument when that 50 argument, I argued on this case of 50 years. The argument of the learned attorney was he gets appointed as 50. Then he'll keep getting extensions.
For 3 years.
Again and again. Till
For
he
3
reaches,
terms, sorry.
yeah, till he reaches 65.
62.
No, some members are 65 like that. Whatever it is, you'll keep getting extension. Therefore, 50 years is not so bad a person. Not subject to correction. I do not know of any case where a person has been given extension. Now, so my submission is once 5 years has been held to be correct, 3 years has been struck down, 4 years also has to go. There should be 5 with an automatic extension of 5 because I'll tell Lordship why. Number one, I'll just conclude my argument because it is very unfortunate that we are taking a confrontational approach.
So because the difficulty is that if the Roger Matthew and 3 judges bench have taken a view that the term should be 5 years,
Yes.
we can't.
No, that's a fact.
Yeah, but
No, what my learned.
strictly speaking, if a member has to be dependent upon them for renewal of the term, would it not tinker with the independence of judiciary?
100%. 100%. Apart, one is the expertise part of it. Other is she has to approach I'm not getting technicalities. He has to apply again. Then again, he'll come down the lower. That's not the point. I'm talking on a matter of principle. And the point I'm just making in conclusion is this, my Lord. Now, today, if your Lordship kindly sees, if your Lordship just visualizes, tribunals are dealing with the entire economic arteries of the country. Please see what are tribunals dealing with. Company law, all taxation, ITAT, CSTAT, GST, every taxation, telecommunications, TDSAT, RERA, electricity, NGT, and consumer law, but yes, consumer law also. So all these are dealt with by tribunals. These are, yes. Sorry, these are all bodies which decide matters which are final on facts And Lordship's jurisdiction as a High Court judge or as a Supreme Court judge is either on a question of law or a substantial question of law, as Parliament may provide. Now look at the tragedy of 4 years, leave alone going to the... Now by putting 4 years or 5 years, what are you doing? The person comes. I agree, my lord, he need not know law. I know my own colleagues who have been very good civil lawyers who have joined the ITAT, then they have been there for 16 years, become ITAT members, 2-3 have become High Court judges also. You can learn
You can learn,
you can
like, when we come here,
yes.
we don't know.
Yeah, your lordship may be a criminal lawyer, but then you sit on the tax bench.
ABC of electricity law,
Yes.
or for that matter, IBC. That's a process of learning, so.
Yes. Lord, at the High Court level, it's a question of interpretation. I'm saying at the tribunal level, since we all appeared extension tribunal, it's a huge question of facts. Classification, income tax, depreciation, transfer pricing, these are all fact driven, not so much law driven. Now, at that stage, if a person has worked for 4 years, let's say after 1.5 years, if a Supreme Court judge has selected him, at least they would have said on merits he's worth the wait. Now, after 1 year, he gets expertise, he works for 3 years at taxpayers' money, and 4 years ask him to go. Now, what's happening is the member process 4, then he finishes from ITAT, goes to CAT. From CAT, he comes to GST. It's a real sad situation, my lord. So my humble submission is, I would beseech the union to say that, look, if you're talking of Viksit Bharat, trillion economy and so on, a robust, independent, efficient tribunal system is very, very vital for the country. I'm not making some kind of a speech, but Lordship will just appreciate. You have a robust income company. Today, what's happening in the company law tribunal? IBC is taking all the time. Parliament says finish in 330 days. Parliament says 270, Supreme Court has added 60 days, 330 days. Report by Daksh says average disposal time is 752 days. Today, anybody practicing in company law will tell you there is no time to take up company matters in the IBC because they have to meet this 30 deadline. So one prayer we have made is to shift company law back to the High Court. But what I'm saying is, if the company law is manned by company law professions, you select him. In fact, the Law Commission recommends make him like an additional judge, 2 years probation, and then appoint him till 62. That's one recommendation. My submission is you appoint him, give him 10-year appointment, at least even at 45, 40, he has the incentive to be here for 10 years with a possible extension. Who is benefited by 4 years? And I'll give a list when in the reply. The vast majority are only retired people who are applying. No young person is coming at all now with this 4-year term. And Supreme Court...
Earlier, the income tax tribunal, there was no such tenure.
No, 62. Income tax, retired 62. So many people have gone at 40, 42. And unfortunately, because of this 66, 33 district judges, many could not get elevated. They've retired as tribunal members at 62. Sistat also 62. Now at 4 years, what is happening, my lord, is, and earlier, if a lordship kindly, I'll show the data. Many tax practitioners joined the tribunal because, my lord, a person may have an inclination for a judicial life. He may not be able to get a High Court judgeship. He takes a tribunal route in the hope that he may be elevated, but at least he likes that particular thing.
Yeah, we are Mr. Balbir Singh's elder brother. We are told that he was one of the finest tax. That's Justice Suryakan told me that he was one of the finest tax.
He was the vice president in Madras.
He's now vice president Delhi.
He was in Chennai.
That time, the age of entry for these members was 35 years.
35.
So somebody at age of 35 or 36 become a tribal member. Somebody staying till the age of 62, the vast experience and the stability it brings to the institution in terms of delivery of justice in the particular field, that reflects in itself. And
Look at the quality of orders.
Yes.
Look at the quality of orders. We used to have ITT journals.
Yes, it's still there.
It's the
Yes. And not, since your lordship is with the Bombay High Court, we talk of Charla Tendulkar bench, Tambe Vaidya bench. Their job was made substantially easy because of outstanding tribunal orders. And I'll tell you, lordship, my friend, Mr. Mahavis, his brother is at him. Now look at the paradox now. I know a member who has joined at 37. He was chosen by Justice Ruma Palan, that same thing. At 37, he joined. He's one of the senior most members. He has not applied for vice president. If he applies for vice president, he's got 6 years to go or 7 years to go. If he applies for vice president, at the end of 4 years, he retires. So therefore now he's sitting in a bench where a recently appointed person is now the vice
He's the vice
president selected.
Yes,
And
he's
he's
the
a
junior
junior member, one of the senior most members.
And that's the one separate writ which is there in this batch itself. And it's from a
But this,
particular member.
this 4-year term is, sorry.
I'm sorry, 52 years of age, appointed pre-2017 under the Income Tax Act. If he takes a vice presidentship, 4 years, he go home at 56. And if he doesn't take it, he continues 62, but he can't be a vice president. He'll be sitting as a junior member to a person who's been appointed at the age of 51. So that's the anomaly of this situation which has been there.
One of the best members today in India.
And also, I remember that if we see best of the lawyers who came on the scene in 70s and 80s, everybody from the tax side everybody has even Mr. Palkiwala practiced for a very, very long time in tribunal. Solely Dastoor practiced for so long and today also in the tribunal. So we are the best of the people who have come. I remember the ones that joined the bar. The ITC dispute was going on in the CSTAT on the cigarette, or the selling price of this. And I used to come from Chandigarh to CSTAT to see it. In the afternoon, Justice Bhatt used to take this bench from the Karnataka High Court. Everybody from
Anil Diwan, Salve.
Mr. Salve, Mr. Anil Diwan,
Sir was there.
everybody, we grew up seeing them saying that, all right, the tribunal can offer this kind of opportunity at that point in time.
But in fact,
UL Bhatt, Justice UL Bhatt.
Not from the Karnataka High Court, he's from the Kerala High Court.
Kerala.
then went to Madhya Pradesh.
Yes. And
In
those,
fact, as it's my
I
friend,
think,
one man.
the earlier chairman was from Gujarat.
yes,
I see it now.
yes.
He was also Justice Bhatt.
Justice Bhatt.
But-
PP Bhatt.
That's the president of there. This is around
And earlier,
2 terms back.
there's no question of High Court judge being a president. When I was ITAT, the senior most would become vice president becomes a president. President would be a non-judicial member also.
But there have been
Because
instances
tribal
of,
seniority because it's
there
a
have been
various
instances, the present chairman is a retired High Court judge.
now the whole system has come like that.
Justice Badang.
Because earlier what used to happen was you become member, you become vice president, become senior vice president, become chairperson. In fact, I remember my friend points out when I was just 1 year in the bar, Mr. Palkiwala had come to Madras to argue a very important case on investment allowance.
Yes.
So we all had got a 9:15 just to reserve our place to watch him argue. He came thrice. to Madras.
Longest of time he's been there, the tribunal.
So, my lord, I've concluded my argument. So, my prayer is, my lord, now, my lord, what is left is, this is the validity part, my lord. What is of urgent importance is my friends' matters, which,
The ICAT and the.
the nodal council has prepared various applications pending. Now, 2-3 things are there, my lord. On ITAT members, there are clear orders saying that those who have joined a particular period, Mr. Jolly will.
Yes, sir.
That they'll go up to 62. Attorney said he will just see whether that has to be contested or it can be accepted. We'll just find out on that. CSTAT and ITAT,
Yes.
those who are taken under the old act and rules. Kudrat Sandhu, there are 4-5 cases which say that they will go on to 62. That, they will argue. I'm not-
That's the challenge to the proviso to section 5, which is the proviso added specifically to curtail the tenure of the 4 members of the SESTAT
Yes.
who have a term of appointment that ends at the age of 62. There are repeated interim orders of this court and final judgments in Madras Bar 3 and now in 4. I just wanted to show one judgment for that, which is already there in the compilation. The first judgment in the compilation, Virendra Huda. That is the basis of the holding in Madras Bar 4. Do my lords have the case law compilation, the first judgment in that?
My lord, just to supplement on CSTAT, Lord, I appear for Rachna Gupta, Lord. This is an application also pending. She's covered
You
by
also
that
must go to
20.
62.
She's also must go to
They'll be
62.
covered by
Lord.
that, covered by the
Same
same
thing, Lord.
proviso. If the proviso is read down as it's
21st
been read
August
down.
order, 21st August order in Kudrat Sandhu, Lord, 3 judges bench.
An attorney is on the.
And the attorney, Lord, had to get back to us, Lord, quite a while back.
I'm sorry for with a volley of apologies here. No, you're not. With a volley of apologies, I thought I should come and personally request the court. I'm still not concluded my arguments before the tribunal. It's sitting again after 1:45 or 2 o'clock. But I will take care of all the interlocutory applications. I'll try to find out how best we can try to address their concern. There, I have no other issues or concerns at all. But as far as the validity, I've prepared a very brief note for your lordship's consideration. It will be shared right now. If your lordship give me an indulgence till Monday, I just want to place some very important concerns why Government of India has taken a particular stand. Otherwise, you would have probably kept all those things which are being articulated before the bench. And I don't think this law should be looked at on an anecdotal basis. Many things will happen when you shift from one paradigm to another paradigm, one scheme to another scheme. Therefore, a law should take care of all those transitional aspects. If not, the law should be bad. I don't think the court will take that into account. So how best we can iron out the crease is what we can try to do. The court may sustain the law but say, look at all these things which are unfortunate consequences. How best we can handle them? That will be a different issue altogether. So I just want a small indulgence, your Lords kindly grant me. So let the note be circulated. Your Lords have the benefit of looking at the note. And I paid considerable attention to the issues. I thought I'll implore Lords to give me a last opportunity on Monday. And I'll finish my liability, my responsibility today, and then come back on Monday.
No, I have just one request.
So yesterday itself we told you that we'll wait for you till Monday, but
I
not
know.
after
That's
Monday.
how I thought I should at least appear and tell Lordships that it's my responsibility to.
We are grateful to you, but Monday,
I am at your Lordship's disposal.
Either your interaction.
No, that's over today. It will get over today.
No.
We are trying to complete it today.
So by Monday,
That's why-
either your international arbitration concludes.
No,
or you
it will
hand
be
over-
over. No, it will
or
be
you hand
over.
over the baton to Ms. Bhatti. Yeah.
No, it will be over today. It will be over today. We have to
But
do
my
many.
request
We are coming back.
Yes, no, my request is not that this validity can be on Monday, but all the other applications for retirement can be taken after lunch, my lord.
Yes, we have kept today's date only for
Oh, yes.
Please,
Madras Bar Association.
My role is back on Monday, my lord.
Yes. For rejoinder.
I'll come back on Monday.
I told Mr. Datar that all these interlocutory applications are a necessary consequence, as I said, shift
No,
from
but
one
it's serious
regime to
because,
another
they are
regime.
all.
They're all necessary consequences. You can't avoid them. At the same time, probably you can't press them also.
Just take it
Let's
after.
try to find a median way.
At least we'll hear them, Mr. Attorney.
Your Lordship can hear them.
Consequent-
Kindly hear
But
them.
I want to only clarify that these applications are dehorse the validities on 2021 Act.
Yes.
These are all interim orders, 9 Kudrat Sandhu orders are there, where Learned Attorney General at that time said that those who have been appointed under particular
Old
rules.
section.
6-2. So they have to be put in a separate bucket and dealt with, like this Kudrat Sandhu, I mean,
Because in
Rashna 6 that.
my
they have to be
written
appointed.
submissions, I have put it
On the
chronologically
lighter-
with each order.
Yeah.
If it
On the
is
lighter
found-
side.
So just,
On the
if my lords
lighter
will see
side.
this,
one
This
minute.
could have actually been resolved.
No, no, this is a full chart has been given here.
just
Resolved by the union.
I don't think they should labor very hard on this matter. Wherever there is a
because
possibility
they
of
are
finding.
retiring in
1 minute,
December
Mr.
because
Datar.
they've been on
1 minute,
tenterhooks.
1 minute, please.
Let the attorney address this.
No, I was only saying wherever possible, we'll try to iron out the creases. If there is a real difficulty, I'll come back and tell you, Lordship. Government, if my predecessor has spoken in one voice, I speak on the same voice. I will not take a different stand.
Anyway,
But
let us know as to what are their problems are.
your Lordships will kindly hear them.
We'll do it after lunch, not unless they want to make a statement, because this is
No,
with
okay,
respect.
okay,
not
take
taken
it
enough
up,
time.
Take it up. Let's take it up.
No, the chart has been prepared by,
So why don't you give us a consolidated chart of all?
fully even, Mr. Samarveer Singh, nodal council has done it.
We will come at.
Let's,
The submissions
Grateful
on
to
this
your
are already filed with us.
apologies to mention a matter.
This is not a time to mention a matter.
Sorry, Milords, there's a grave urgency. That's why I'm.